Hello all, a warm welcome. This is Saranya Venkatesh. The topic which we are going to see now is Prevention of Money Laundering Act. Why this particular act becomes very relevant is recently the Supreme Court it upheld the core amendments which are made to the Prevention of Money Laundering Act. So before getting into the act and the amendment, we will see two important concepts, dirty money and the money laundering. So first, what is a dirty money? It is the money which are acquired through various criminal activities like illegal arms sale, smuggling, drug trafficking, prostitution, insider trading, bribery and computer fraud. So the money which are generated by these kind of activities is known as dirty money. Then comes the money laundering. Money laundering is actually the process of conversion of these dirty money into legitimate money. So the money from these criminal activities is considered dirty and the money laundering process launders it to make it look clean. So it is a serious financial crime that is employed by white collar and street level criminals. So now we will see what is the Prevention of Money Laundering Act of 2002. So this act was enacted in response to India's global commitment, that is Vienna Convention, to combat the menace of money laundering. So what are all the global commitment in regard to money laundering is, we have United Nations Convention against illicit traffic in narcotic drugs and psychotropic substances of 1988 and Basel Statement of Principles of 1989, and we have 40 recommendations which are provided by Financial Action Task Force on Money Laundering in 1990, and also Political Declaration and Global Program of Action which was adopted by the United Nations General Assembly in 1990. Now we will see what are the objective of this act. So this act mainly seeks to combat and prevent money laundering and to confiscate and seize the property which are obtained from that laundered money, and to deal with any other issue connected with money laundering in India. This particular act also proposes a punishment under section 4. This act is applicable to all persons which include individuals, companies, firms, partnership firms, association of persons or incorporation of any agency. So now we will look into a important law enforcement agency of India which deals with prevention of money laundering, that is Enforcement Directorate. This Enforcement Directorate is a law enforcement agency and economic intelligence agency which is responsible for enforcing economic laws in India and fighting economic crimes. It comes under Department of Revenue, Ministry of Finance. The origin of this directorate goes back to 1st May of 1956 when an enforcement unit was formed in the Department of Economic Affairs for handling exchange control laws violation under Foreign Exchange Regulation Act of 1947. So the prime objective of this Enforcement Directorate is the enforcement of two key acts of India. The first is Foreign Exchange Management Act of 1999 FEMA and the Prevention of Money Laundering Act of 2002. Now we will see what are the core amendments which are recently made to the act which the Supreme Court upheld, and various petitioners have filed petitions. The first, this act gives the government and the enforcement directorate the powers of summon, arrest, raids and makes bail nearly impossible, and also it has shifted the burden of proof of innocence onto the accused rather than the prosecution. So over these provisions, over 240 petitions were filed against the amendment which the challengers claimed it to violate personal liberty, procedures of law and the constitutional mandate. So we will see all these core amendments which are in news of the Prevention of Money Laundering Act. The first is the summoning issue. What is the issue here is, the accused are primarily summoned by the ED and made to sign statements on the pain of threat of the arrest, and that time the ED assumed the power of a civil court. So this particular provision is against Article 20 of 3, that is fundamental right against self-incrimination, and a particular person they cannot claim that protection under this. But the Supreme Court clarified that the Statements were recorded only as a part of an inquiry into the relevant facts in connection with the proceeds of crime, so it cannot be equated to an investigation for prosecution. So this is the first issue in the amendment, that is summoning. The second issue is about arrest. The Enforcement Directorate could arrest a person even without informing him of the charges. So this power is clearly a violative of right to due process enshrined in Article 21 of the Constitution. And also, besides Article 22, which mandated that no person can be arrested without informing him or her of the grounds of the arrest, this provision has been contended. But the court said the supply of copy of ECIR is actually Enforcement Case Information Report in every case to the person concerned is not mandatory. It is enough if EED at the time of arrest discloses the grounds of such arrest. And also the Supreme Court rejected the notion that the Enforcement Directorate has been given blanket of powers, search of person and property and seizure. So we have saw about ECIR, Enforcement Case Information Report. Now we will see what is the issues with this ECIR. This ECIR is actually equivalent to FIR, which is considered an internal document and not given to the accused. So throughout the procedure, the accused does not even know the fact of allegation against him, because this ECIR is only document which contains the allegation but which is not supplied to the accused person in case of arrest. So this is the issue regarding the arrest. The next is regarding bail. When we talk about bail, we have a condition called twin condition under this act, which rendered the hope of freedom non-existent for the accused. So what is this twin condition? The first is there should be a reasonable grounds for believing that the person not guilty of such offense, and the second condition is the accused is not likely to commit any offense when he is on bail. So this is the twin condition under the bail under this amendments made to the PLMA Act. But in 2018, under Nikesh Tarachand Shah vs Union of India case, the Supreme Court had actually struck down this section, that is twin condition section, on the grounds that the conditions only apply to those offences which are listed in Part A of the schedule, which attracts a prison term of 3 years and more, and not of the offence of money laundering itself. But now the Parliament have actually re-enacted the section with a change. What is the change? That this condition would apply to all the cases under PMLA without any reference to scheduled offence. So the getting bail has become very difficult in this core amendment made to the PLMA Act. But the Supreme Court said the under trials could seek bail under section 436A of the Code of Criminal Procedure if they had already spent 1/2 of the term of punishment in jail for the offence prescribed in law. So this is the issue of bail. Then comes the burden of proof. Here the burden of proof resting heavily on the shoulders of the accused. Once the issue of admissibility of materials supporting the factum of grave suspicion about the involvement of person in the commission under this act is accepted in law, the burden must shift on the person concerned to dispel the suspicion. So the burden of proof resting heavily on the shoulders of the accused. So this is the issue of burden of proof. Then the amendment made is for the attachment of a property. Here the petitioners argued that this provision, they objected the powers bestowed on ED to attach a property as a proceeds of crime, because the petitioners have contended that even properties which were not proceeds of crime could be attached by the agency. But in this regard, the Supreme Court has clarified that Section 5 of the PLMA concerns with the provisional attachment of property, but it cannot be used by the agency mechanically. It cannot resort to action against any person for money laundering on the assumption that the property recovered by them must be proceeds of crime. So the court said It is actually provided a balancing arrangement between the interest of the accused and that of the statement. So further, if the accused was eventually absolved of the crime, no further action could be taken against the attached property which is suspected to have been linked to the crime. So these are the issues in the core amendment. The first issue we saw is a summoning issue. The next is about arrest. The next is about bail, and we have saw about ECIR, enforcement case information report, and we saw about burden of proof and the attachment of a property. So these are the amendments made to this act which are under severe criticism. So this is all about this act. I hope you understood. If you have any doubts, leave your doubts in the comment section and hit the like button and share the video with your fellow UPSC aspirants and subscribe to Get Into IAS. Thank you so much for watching this. I'll see you soon in the next video. This is Saranya Venkatesh and thank you.